לפי הניסיון שלי, אני אומר בעברית, בארץ זה אף פעם לא עובד. Good morning, Mr. Chairman, dear colleagues, ladies and gentlemen.
לא שומעים.
תרדו, תקרבו.
Now you hear? Okay. I hear myself. Okay, the application of religious law in contemporary legal system is by no means an exclusively Israeli phenomenon, as we have heard also in earlier lectures. The continuous process of migration of people of different religions has given rise to legal problems relating to religious laws and traditions in a variety of countries. It is evident in situations of private international law, conflict of laws, especially but not exclusively in the field of family law and in relation to Muslim couples. Interestingly, in the United States quite recently, an Oklahoma constitutional amendment prohibited the application of Muslim law and laws of other cultures by state courts, and this amendment, which has been accepted by 70% of the population, has been blocked by a preliminary injunction issued by a federal court, and recently, January this year, the injunction has been upheld by a federal court of appeal as being a violation of the Establishment Clause because it discriminated among religions. The case is Awad against Syrians, 2012. But in my present lecture, I will concentrate on the situation in Israel. First, a general comment on the application of religious law in Israel. It is important to know the historical background, has also already been shortly mentioned. Palestine was for almost exactly 400 years part of the Ottoman Empire. The Ottomans granted, by means of the so-called millet system, legal autonomy to the religious communities in matters of personal status. As a result, the religious tribunals of the various communities, among them rabbinical courts, enjoyed exclusive jurisdiction in matters of personal status, such as matters of marriage and divorce. After the establishment of the British mandate over Palestine in 1922, the system of religious jurisdiction in matters of personal status was in principle maintained. One important change during the mandatory period was a supervision over all the religious courts by the Civil Supreme Court in its function as High Court of Justice. It interfered in cases of excess of jurisdiction by the religious tribunals or in cases of violation of the so-called principles of natural justice. I'm not going into the details. However, religious law as such remained untouched. The system of religious jurisdiction in matters of marriage and divorce under the supervision of the High Court of Israel, High Court of Justice, was maintained after the establishment of the state in 1948. I will concentrate here on some fundamental aspects of the position of Jewish law in the Israeli legal system. One has to remember that the maintenance of the basic status quo in relation to the non-Jewish communities cannot be separated from the Palestinian-Israeli political conflict and specifically from the problem of the national identity of the Arab population living in the Jewish state. The religious jurisdiction is still conceived by many Arabs as a manifestation of natural cultural autonomy, with all the problems of freedom of from religion, etc. But for the Jews living now in an autonomous Jewish state, the religious rabbinical jurisdiction received a completely different meaning. It was no more a grant by a foreign authority of a limited autonomy to a religious minority, but an expression of the Jewish nature of the state, and henceforth part of the controversial issue of the relationship between state and religion. The rabbinical jurisdiction in matters of marriage and divorce, and the application of orthodox halachic law was legislatively ordered by the Rabbinical Court Jurisdiction Marriage and Divorce Law of 1953, also been mentioned in one of the lectures. It has, however, to be noted that already during the British Mandate, a distinction was made between matters of personal status that were subject to exclusive jurisdiction of religious tribunals and those in relation to which there was a so-called concurrent jurisdiction, meaning that the parties could agree to submit the matter to a religious court. In the absence of agreement, religious law was to be applied by the competent civil secular court. In relation to rabbinical courts, this system has been maintained by Section 9 of the law of 1953. In matters of maintenance, the choice of jurisdiction is granted. In matters of maintenance, the choice of jurisdiction is granted to the wife under Section 4. I'm only saying very parentheses, in relation to Muslim court, Christian courts, a change has been made by the family court indirectly, and the exclusive jurisdiction has been limited. It was broader. If you compare the exclusive jurisdiction to Jews in relation to Jews and the exclusive jurisdiction in relation to non-Jewish I'm sorry. In relation to non-Jewish communities has been larger, and it has been now made the same in a law in 1995. That's just a parenthesis. In these cases, where Jewish law has to be applied by the secular court, since 1995 is generally the family court, the reference is to the autonomous orthodox halachic law. I called it, in one of my books, direct application of Jewish law in order to distinguish it from indirect application, where a specific content of Jewish law is at the base of a secular law. It's not a reference, it's not an incorporation of religious law, but it's drafted and expressed in a secular law enacted by the Knesset, like, for instance, the law prohibiting the raising of pigs enacted in 1962. So this I call an indirect application. It's because it influenced the content of secular law, but it's not an autonomous reference to an existing legal system. In a number of cases, the question whether the secular law, using a notion of religious significance, actually refers to Orthodox Jewish law, this question might be in some cases controversial. I myself had a minority opinion about one of these questions. For instance, if you take the notion of conversion in the law of return, what does it mean? Is it a reference to Orthodox law, or is it a more secular notion of conversion, including also reform and conservative different trends inside Judaism or not? So the expression of conversion might be a reference to a specific Jewish law, which is the Orthodox law, or it might be a more secular sense, which includes also different ways of it. A similar problem arose in the law on holy places. I had a minority opinion on this topic, on the notion of custom, because according to the law of holy places, the customs, it has been mentioned, the problem of women praying, putting on the shoulder, praying, and the law, there was a law on the holy, it's actually a regulation by the ministry which said that the customs have to be upheld. And the problem was, what does it mean, custom? Is it a reference to a specific Orthodox custom, or is it a secular notion of custom? And the majority of the Supreme Court decided that it's not a religious notion, it's not a reference to the halachic law, but it's a more, which in my view, I had some reservations, but I'm not going into it. It's just I wanted to show you that even if you use a notion coming from religious law, it doesn't specifically mean that it's a reference to an autonomous system of Jewish, Orthodox Jewish law. Now, the very subjection of all the Jews, believers and non-believers, to Orthodox Jewish law in matters of marriage and divorce, and the exclusive jurisdiction of rabbinical courts in matters of marriage and divorce, and the absence, which has been mentioned, of civil marriage, is a most controversial political issue. It is resented not only by agnostics, but equally by the members of different Jewish religious movements, such as the adherents to conservative or Reform Judaism. But as mentioned before, this issue makes part of the problematics of the relationship between state and religion. I am concentrating here on the more specific problem relating to the application of Jewish law by secular courts. Moreover, inside religious law, there are serious tensions between the traditional norms and the requirements of modernity, experienced also by believers. One major example constitutes a problem resulting from the nature of Jewish divorce, similar to the Muslim, but I'm not going to the Muslim divorce, which is the divorce, the Jewish divorce, is a unilateral private act executed by the husband, the transmission of the get, the transmission of the bill of divorce. In other words, not the rabbinical court constitutively declares the dissolving of the marriage, but it is a result of the transmission of the get to the husband. The problem is experienced even by Orthodox Jews, and inside Jewish law many attempts have been made, all according to its own methodology, religious law methodology, to cope with the difficult problem. The problem of agunah literally means the woman chained to her marriage because of the refusal or the impossibility of the husband to deliver the get. The impossibility can have two reasons. One, he ran away, you don't know where it is, or he's insane and incompetent. Then you have the serious problems of the agunah. Agunah means, actually, the word agunah means anchored into the marriage, which is bound to marriage, cannot come out of it. There are many problems, I'm not going into it, many suggestions to solve it according to the Orthodox law, by conditional marriage, etc., opposing the get. I'm not going into the details. From a historical ideological point of view, one can discern two basically different approaches to the place of Jewish law in the Israeli legal system. And I make a difference between a religious approach and a national cultural one. The religious traditional approach views Jewish law, the halakha, as divinely ordered, and its application is a vital religious task. Hence, it is the duty of the Jewish state to apply it in all fields. This approach accepts the metaphysical premises of the halachic system, and especially the binding character of all the traditional sources. One of the characteristics of Jewish halachic Orthodox law is its comprehensive nature, dealing with all manifestations of human life, personal and interpersonal, thus constituting a full alternative to all domains of secular law, inclusive contracts, tort law, etc. We have. So this is a major difference to Christian traditions, where for long ago the ambit of religious law, of canon law, has been limited to specific issues. It's no more applicable. The churches leave these matters to the state authority and autonomy. This is not in Jewish law. It's similar in Muslim law also. You have similar tendencies. In applying the religious law, one has not only to use the internal tools, its conceptual framework, and the general method of handling the numerous, partly conflicting sources, very common in Jewish law, conflicts of opinions, but must equally or even primarily, strive for the achievement of the general religious aims and ends conceived by the individual decider. Our sages, already in ancient times, were fully aware of the impact of the personal ideology of the decider upon the concrete legal solution. In other words, they were conscious of the fact that the legal outcome of a case was not the result of a merely logical, conceptual reasoning, but the personality of the judge played inevitably a major role in the decision-making. This can be seen, to give an example, from the insistence of Jewish law that one of the judge's requirements was his ability to, I quote, purify the reptile on the basis of the Bible. Sanhedrin. It's in the Talmud Sanhedrin. A reptile is a symbol of impurity. And it is specifically declared to be impure by the Bible in a number of places. So how can you demonstrate your ability to purify something, which means that the sages were aware that you can do it by legal reasoning only. By purely legal reasoning, and you have to show it. In the Talmud itself, they have difficulties. How can you find the idea that a reptile is pure? And there are some suggestions how you can reach this conclusion inside the halachic framework. It shows that the rabbis were convinced that by means of purely legal conceptual reasoning, a judge was able to reach even the most absurd result from a religious point of view. So what prevents him from reaching this unreasonable result? It is his ideology, his personal commitment and loyalty to the system, called in the religious Jewish context, Yirat Shamayim, the fear of God. So what hinders him to reach this result? He has the possibility, he had to show his possibility to reach this I would say, nonsensical result under religious law, but he doesn't do it because he needs to fear God. This insight, which today is quite common knowledge of all those who deal with the judicial process, affects profoundly the situation where the religious law is to be applied by a secular judge. To entrust the secular courts with the application of religious law signifies that the outcome might be influenced, and probably will be so influenced, by the secular ideology of the individual judge. Quite early, it has been acknowledged by the Israeli Supreme Court that the application of religious law by secular courts differs from that exercised by religious courts. Incidentally, the difference of outcome is also caused, besides ideology, by the different rules of procedure and evidence. In a famous dictum made years ago by Justice Silber, I'm quoting, "Jewish law applied in a civil court is not a Jewish law applied in a religious court. There is a difference in approach, in method, and sometimes also in the actual content of the judgment." I can give many examples of how secular judges, among Chaim Cohen, who was an expert in Jewish law, how he reached conclusions which were unthinkable and rabbinical courts ever reached. I only give the case of Rufeisen, yes, where he was quoting a biblical, midrashic quotation. Actually, I would say, I'm giving it as an example, how you can completely distort the sources if you want to do it. So it's against the tradition. He said that even a converted Jew may be considered to be Goy Shomer Emunim. Means he is a Gentile, how do you say, Emunim, who is observing his loyalty to Judaism. So even a converted Jew is still a loyal Jew. Because I would say that no Orthodox Jew would ever reach this kind of conclusion. But it's written in the judgment. It was a minority opinion, but nevertheless. The quotation of Justice Silberg illustrates a great difference in the rules of evidence. Hence, the handling of religious law by the secular organs of the state is fundamentally problematic from a religious point of view and affecting his religious legitimacy. No wonder that ultra-Orthodox circles consider the whole secular judicial system as illegitimate from the religious point of view, even when they officially were applying religious law. As a result, they require from Jews to avoid that jurisdiction and to bring their disputes before rabbinical courts that function under state laws as arbitrators. The secular courts have reacted quite resentful to the very notion that Israeli courts are to be considered illegitimate under Jewish law. A good example is a recent magistrate court decision where the judge even considered a halachic decision of a rabbi that religiously prohibited the enforcement of a court order, and he said this is a criminal offense under state law. This very rabbinical decision. It was a case where a person, it's a recent case, where a person asked the rabbi if he may reveal the person who signed a forged check and he was criminally indicted, if he may reveal the name. And the rabbi said, no, you don't, against the order, the court ordered him to reveal it. And he claimed the privilege under religious law not to reveal it because there was a rabbinical decision saying you cannot reveal the name to a secular court. The judge, who is very resentful, said that this might be a criminal offense from the rabbi, hindering the procedure of state. But it shows you the tension between the religious view and the secular courts, where they are considered by many Orthodox people as not to be legitimate under the Jewish law, even if they apply Jewish law. In this sense, many years ago, I pointed out that the very incorporation of religious law into state law affects its religious significance in changing its basis of its validity, or in Keynesian terms, its basic norm. In other words, it has been mentioned also here, Jewish law is not valid because of it being divinely ordained, but because of the secular legislator's incorporation into the legal system. But in practice, the incorporation of religious law into the secular system has created for the judges also a direct problems of application. Now, even if you forget all about the basic norm, that it's not the divine order, but it's the basic norm of the secular legislature, etc., there are inherent problems of applying religious law in a second. I'll give you an example where I was sitting in the Supreme Court. It's the case of Kalbinyan. The case is called Kalbinyan. It's the name of one of the litigants. In that case, the Supreme Court, I'm sorry I'm going to some technical issues, but it's because it's an interesting issue, I will explain it. The court dealt with a case of culpa in contrahendo, which means the violation of good faith during contractual negotiations. There were contractual negotiations and they reached the final point, and then the party who already had agreed to sign the contract, he refused to do it. And the problem was, what is the sanction for this non-good faith behavior? The legal problem concerned the appropriate sanction under Section 12 of the Contract Law, General Part of 1973. The principle of culpa in contrahendo, which we took from German law, it was Hering's invention in the 19th century. The duty to behave in good faith during negotiations. The Problem was, can you grant positive damages, which means the expectation damages, the benefit of the contractual not realized bargain, or have you to has to be satisfied only by mere reliance damages? So the distinction was, can the court impose upon the violating party of the good faith the benefits of the contract which has not been contracted, or has the other party only a right to get the expenses he had during the negotiation? The court decided in a positive way. I'm not going. It's actually quite a revolution in Israeli law that the violation of culpa in contraendo can give you the positive damages, the expectation damages. A preliminary observation in order to understand the background. Under Section 1 of the Foundations of Law Statute of 1980, it's the provision, has been mentioned here already, dealing with the problem of lacuna, of the gaps in the law. It's a parallel article of in Swiss law is Section 1 of the ZGB, the Civil Code. And I'm quoting, where the court, faced with a legal question requiring decision, finds no answer to it in statute law, or case law, or by analogy, it shall decide it in the light of the principles of freedom, justice, equity, and peace of Israel's heritage. I shall return to this section later, to the controversy over the exact significance of this section. But assuming for the moment, as I assumed in that case, that Israel's heritage relates to traditional Jewish law, it's controversial, but it's interesting. They were using an ambiguous term. They didn't want to say Jewish law or Hebrew law. They said Israel's heritage. What does it mean? I assume that it refers to Jewish law. I did it in the mentioned case of the Supreme Court, and I was always also assuming the existence of a lacuna in relation to the specific legal questions of damages in culpa in contraendo. How should the result be under Jewish halakhic law? That was the question I was putting. Assuming all these questions which might be controversial. I'm a Keynesian, there are no lacuna in the law anyway. To say it's a lacuna, a gap in the law, is an ideological answer, because then you decide between argumentum a contrario, argumentum per analogiam, you could solve it, and if you say that there's no solution in the law, maybe I will explain a little bit later. The problem of gap in law is a classical theoretical problem. To what extent it's in Swiss laws, the whole background. I found, now I'm assuming there's a gap in law, I'm assuming Jewish heritage means Jewish law. Now how are we proceeding? I found that the sanction in Jewish law for a violation of the proper conduct in negotiation was a purely moral one, namely a public curse of the guilty party in the synagogue, or a general condemnation of his conduct by the rabbis. So it's Misha Para, you know. It's the curse who sanctioned the generation of Palaga, which built the Tower of Babylonia, which just we read it last few weeks ago in the Torah, in the weekly portion. This is a sanction provided for in Jewish law in the synagogue where the litigants participated at the prayer. Somebody, the rabbi, goes up on the bima and he declares, God who punished this will punish you. That's the sanction provided by the Jewish halakhic law. Now how can we in Israel today, how do we apply it? How can a secular court apply this sanction? Could it develop the moral or religious sanction to a legal sanction? Like the imposition of positive damages upon the party behaving malafide during negotiations. No doubt, the idea behind the moral religious sanction was to induce the party to perform the contract. Given the fact that in contemporary Israeli society the religious, merely moral sanctions are for the great majority of litigants not efficient. He won't go to the synagogue anyway. He wouldn't care what the rabbi will declare about him. Doesn't believe in the curse also. So what would it mean? The question was, could the secular court change the traditional religious solution by imposing directly legal sanction? I put the question in my judgment without giving an answer. The same non-answering of a difficult question was subsequently done by two judges of the District Court of Jerusalem, quoting myself. They also didn't know how to translate it. It exemplifies one of the problems of applying even a good faith, religious ideology, a religious law in a secular, modern secular society. This brings me to the second approach to Jewish law, which I call the secular national one. The original idea was to revive the Jewish law as an expression of the national cultural heritage of the Jewish people. This idea was influenced by Savigny's historical school, which conceived law as an organic product of a specific Volksgeist, spirit of the people. Now, it is a fact that the law was at the center of the Jewish people's intellectual efforts for more than 2,000 years. The result was a huge legal literature and a continuous occupation with legal and moral questions in all fields of human life, no doubt. On this background, an intellectual movement was created in the early 20th century by Russian Zionists. Two of the dominant leaders were Samuel Eisenstadt, he was a fervent communist, who was educated in Switzerland, and the second one, Paltiel Dickstein, Dekan, who studied at the University of Odessa. Eventually, in the late 1910s, the so-called Hebrew Law Society was established in Moscow, furthering the revival of Jewish law. In the wake of the Russian Revolution, the society was disbanded and some of its members emigrated into Palestine. They joined a parallel movement that had been created earlier in Palestine, the so-called Mishpat HaShalom HaIvri, the Hebrew Courts of Arbitration, that aspired to maintain an independent, voluntary jurisdiction in order to practice the revival of Jewish law. A Jewish law not as a religious, but the idea was that you can take out from the religious tradition a center of cultural significance. The movement of revival declined in the early 1930s and eventually failed. It was, however, renewed towards the establishment of the State of Israel. Was it this time successful? The answer is, in my view, negative. And without going to details, I would like to refer in a very summary way to some fundamental aspects concerning the whole idea of reviving Jewish law in a secular environment. In my view, the historical school's conception, thank you very much. The historical school's conception of law being an organic growth of the Volksgeist is highly romantic. I conceive most of private law in modern society, in the world of globalization, to be rather a technology than a cultural product of a specific nation. No doubt, in many specific fields, in some specific fields, such as family law and bioethics, the traditional culture may still be decisive. But in most other matters, the actual solutions tend to converge. So what distinguishes the different traditional systems of law are not the solutions, but the ether, the way to reach the solution, the legal tools, the conceptual framework conducting to the solutions. The same is true for Jewish law. the solutions in private law disputes are necessarily limited. You don't have too many solutions. Many times only 2 or 3 alternatives. And in most cases, the actual solution in Jewish law will find a parallel in a number of other laws. The difference will therefore lie in the use of specific legal sources and its particular concepts. Moreover, Jewish law considers itself, as mentioned, as to be divinely ordained. Any attempt to secularize the system and codifying it, which means to exclude from the judicial process the reference to the multitude of binding sources, you exclude the huge rabbinical literature, all this will destroy not only the underlying religious dimension, but equally any possible cultural significance. Moreover, from a purely national cultural point of view, I doubt the existence of a specific cultural significance of contemporary private law, especially in view of the strong tendency of its unification, both on a regional and global level. I'm very skeptical about some of the premises of Professor Menachem Maltmus in his recently published comprehensive book, Law and Culture in Israel, at the threshold of 21st century, but I'm not going into it. Another problem, practical problem, constitutes the actual state of Jewish law in these fields. For most jurists, the access to it is most difficult, being not codified in a modern sense, and in view of the immense number of sources. In addition, if not most legal problems, there are differences of opinion. In the public field, the public law field, the great difficulty is that a modern liberal Jewish state is completely foreign to the Jewish tradition. Since from antiquity there was no autonomous Jewish state, the relatively very few Jewish sources that dealt with Jewish statehood referred to an idealized past or to an ideal Messianic state in the future, to take Maimonides as an example. One of the few, the Shulchan Aruch doesn't deal with the Jewish state anymore. And if you take Maimonides as an example, you can see to what extent he is dealing with the Messianic state, the ideal Messianic state in the future. Nevertheless, the tendency of having recourse to the Jewish legal tradition as a national cultural heritage continued. One of the results was already mentioned, as I mentioned, the law enacted in 1980 relating to the lacunae in the legal system. I quote it, I will repeat it, where the court faced with a legal question requiring a decision finds no answer in the statute law, case law, or by analogy, it shall decide in the light of the principles of freedom, justice, equity, and peace of Israel's heritage. Then the Article 46 of the Palestine Order Consent was abolished, which referred to English common law. The notion Israel's heritage is indicative of the ambiguous attitude in relation to Jewish law. It can be interpreted in different ways, national, cultural, or religious. Moreover, the values mentioned, freedom, justice, equity, peace, are very often contrasted, requiring a value judgment. Our sages actually claim that where law prevails, there is no peace. And where there is peace, there is no law. Shalom ein mishpat. So how can you combine it? Even if you go according to, because I was at Sanhedrin 6b in the name of Rabbi Yeshua ben Korcha. And further, where there is law, the Talmud says, there is no charity. Charity in the sense of equity. And where there is charity, there is no law. So how can you combine equity, law, freedom, justice, where the notions themselves are contradictory? Even according to the Jewish heritage. They are contradictory. The solution by the Talmud says it's compromise, settlement. So how accommodate this principle in the framework of law according to Israel's heritage? As a matter of fact, The very interpretation of the foundations of law, statute provision, provoked a strong controversy among the President of the Supreme Court, Aaron Barak, and his Deputy Justice, Menachem Elon. It's a case in the 90s. Justice Elon is one of the great partisans of the reception of Jewish law into Israeli law out of cultural and religious reasons. He views the mentioned law as a broad opening in principle towards Jewish law, whereas Justice Barak considered this to be a provision for merely filling gaps in the law that by nature of its limited extent, because as I said, the very finding of a lacuna is a subjective value judgment, because as I said, the alternative is or analogy, which is a means of closing gaps in the law, or an argumentum a contrario, which we call in Hebrew hesder shlish. There is no doubt that the wording of the law supports Barak's conception. The heritage of Israel is relevant only where there is no answer in the statute, case law, or even by analogy. Hence, only in very rare cases there is a lacuna in this sense. However, in practice, a number of judges at all levels, mainly those with religious and Talmudical background, who are very knowledgeable in Jewish law, referring their judgments to Jewish law, even where there is no question of a lacuna, and the reference is actually without any practical effect, since the solution is according to the positive secular law. But many judges, even today, you can read, the book has been published with all the references to Jewish law, where there is no need to refer to Jewish law. But the judge, if solution in Israeli law is so I will tell you what's the solution in Jewish law. It's similar or a little bit different. As you may have concluded, as you may have understood from my previous remarks, I'm very skeptical about the real cultural impact of these judicial references to Jewish law. Who at all is reading judicial decisions? What the judges are imagining, who is reading it? The general public doesn't read judicial decisions. They rely on what is reported in the television or in the media. And the media report only cases which have we have hundreds of thousands of cases a year. How many cases are, let's say, drawing the public eye, which have ideological, private law issues in contract, torts, etc. Nobody reads actually the cases, and you can ask. I never had any illusion about what I'm writing will survive. Who knows how many? You are writing for the other judges who may have a similar case. The winning party is not interested what are the reasons, and the losing party is anyway angry with what has been written in the case. He also reads. So, and the students who are forced to read decisions, they take many times a summary or an extra prepared by somebody and paid for it somehow. So not to read it. So if you, I never think that if you put in 200 pages in the decisions, somebody will read it. Okay. The general public is not interested, I said, in legal problems resolved by the courts. The assumption of a significant cultural influence on the population by judicial decisions is, in my view, a romantic illusion. Thank you.